Your honors, is right through those doors. Thank you, Your Honor. We have no further witnesses today.
She won't last 5 minutes up here, said Dr. Marcus Webb, adjusting his mic with a smile that had never once doubted itself. He was standing at the front of the Whitmore Law School moot courtroom. 200 people, 3 sitting federal judges on the panel, a legal affairs correspondent from CNN in the third row. He gestured with open arms toward the back of the room, where a young black woman in a cleaning uniform was emptying the trash bin by the door. In fact, he said, warming to the room, I'll make it interesting. First person in this hall who can poke a legal hole in my argument. A real hole, not a law school hypothetical. I'll withdraw the case myself. Right now? In front of everyone. He laughed, even her. He pointed at the woman with the trash bag, maybe especially her. 2 of the 3 judges did not smile. The CNN correspondent put down her pen. The woman by the door did not look up. She tied the trash bag. She set it by the wall. She pulled out a fresh liner. She did not hurry. And then she turned around. 1:02. Rewind 6 hours. It's 3:45 in the morning at the Whitmore Center for Law and Society, and the only person on the second floor is Naomi Osei. She's 32 years old. She has been the overnight custodial supervisor here for 8 years. She went to Georgetown Law for 2 years before she dropped out to take care of her mother, and when her mother died, there was no money left to go back, so she came here instead, not to study, but to clean. She has never told anyone this. Not her supervisor, not the other staff, not the security guard who brings her coffee at 2 a.m. and talks about his daughter's soccer games. She keeps a legal pad in her cart, not for notes, for drafts. She's been drafting the same brief for 4 years, the same brief nobody asked her to write, for a case nobody hired her to argue, on behalf of a plaintiff named Dolores Whitfield, who has no lawyer. Dolores Whitfield is 71 years old. She lives in a walk-up in Roxbury. She has been trying to reclaim the mineral rights to a small piece of land her grandfather purchased in 1946, land that was reclassified in 1973 by a regulatory decision that Naomi believes was procedurally invalid. Naomi found the 1973 filing in the archived case boxes on the 4th floor, in a box labeled for disposal. She found it 3 years ago. She has not thrown it away. It is in her cart right now, in a manila envelope under the spare trash liners, next to a worn copy of Federal Administrative Law, 3rd edition, with so many post-its it barely closes. Now meet Dr. Marcus Webb, 48 years old, senior partner at Aldrich Webb & Cruz, the most quoted appellate litigator in New England. He's been on the cover of American Lawyer twice. He has a book called The Architecture of Argument that they assign at Yale. His win rate in Federal Circuit arguments is 81%. He walks into a room the way a person walks into a room they already own, shoulders wide, pace unhurried, a slight pause at the door so people can register that he's arrived. He is here today at Whitmore's annual Public Policy Colloquium to present the closing defense brief in a case called Aldrich versus Commonwealth of Massachusetts, a mineral rights reclassification case that has been working its way through the courts for 3 years. It is, in Naomi Osei's assessment, the same family of case as Dolores Whitfield's. Webb is representing the other side. Webb has never heard of Dolores Whitfield. Webb does not know Naomi Osei exists. Webb arrived this morning in a black car, handed his coat to a student volunteer, and has been on his phone in the green room since 8:30. The case he is about to argue is airtight, in his view. He wrote the brief himself. It is 87 pages. He is proud of it. There is one problem with it. Naomi found it 4 weeks ago. The colloquium opens at 9. 3 sitting federal judges on the panel: Judge Anita Correa, Judge Samuel Park, Judge Diana Ostroff. 200 attendees: faculty, students, clerks, journalists. The CNN correspondent, Claire Mendez, is here because the Aldrich case has become a flashpoint in ongoing debates about property rights and regulatory overreach. She has been told this morning, maybe historic. She is not sure she believes that yet. Webb takes the podium to extended applause. He is everything the room expects: precise, authoritative, fluent. His argument builds like a cathedral, each pillar placed, each arch confirmed before the next span is attempted. The room listens the way rooms listen to people they already believe. He reaches his central pillar at the 40-minute mark. The 1973 reclassification, he argues, was executed under valid regulatory authority granted by the 1969 Federal Mineral Interests Act. That authority has been affirmed 3 times at circuit level. The chain of precedent is clean. The plaintiffs trying to challenge the Whitfield class cases, including Dolores Whitfield, have no procedural standing because the original grant of authority was never invalidated. He pauses. He looks at the room. He looks satisfied. This is not complicated, he says. The 1969 Act is clear. The 1973 action was valid, and any argument to the contrary fails on first contact with the statute. He smiles at the panel. I'm confident you'll agree. Judge Correa nods slowly. Judge Park makes a note. Judge Ostroff is still. It is now that Webb, feeling generous, decides to make the offer. I'm going to do something unusual this morning, Webb says. Because I believe in this argument, and because I think it's important for students of the law to understand what a truly defensible brief looks like, I'm going to invite challenge. Anyone in this room. He spreads his hands. Anyone who can show me a genuine, cited procedural flaw in my 1969 chain of authority, I'll withdraw the brief. Today, on record, he laughs once. I've made this offer at 3 other institutions. It's never been accepted. His eyes drift to the back of the room. To Naomi. She is relining a trash can by the door. Anyone, he says again, with a smirk that has traveled a long way from warmth. Even the cleaning staff. Claire Mendez puts down her pen. Judge Ostroff does not blink. Naomi does not look up. She ties the bag. She sets it by the wall. She turns around. She walks to the front of the room. Not fast. Not slow. The way a person walks when they've been waiting 8 years and they are finally done waiting. She stops at the edge of the speaking floor. She looks at Judge Correa. Your Honor, I'd like to use the 2 minutes he offered. Judge Correa looks at her. A long look. Not dismissive, searching. Are you a member of the bar? No, Your Honor. I'm not a lawyer. I'm the custodial supervisor for this building. But he said anyone. The room is very still. Judge Correa looks at Webb. Webb's smile has not moved yet, but something behind it has. By all means, he says, gesturing grandly. Please. Naomi walks to the podium. She does not bring notes. She does not carry the manila envelope, not yet. She adjusts the microphone because it's too high for her. The small click of the adjustment echoes in the silence. She speaks. Her voice is level, clear, carries like someone who has been giving herself arguments in empty hallways at 4 a.m. for years. Dr. Webb, your entire chain of authority rests on Section 4B of the 1969 Federal Mineral Interests Act. You've cited it 9 times in your brief. I've read the brief. She pauses. Section 4B was amended in 1971, not replaced, amended. The amendment added a procedural notice requirement. Any reclassification under the Act required written notice to all affected title holders within 90 days of the regulatory action. I'm saying it contains a gap, Your Honor. Whether that's misrepresentation or oversight, I'm not a lawyer. I'm just the person who cleans the room. 11:15. Webb is still standing. He has not sat down. His jaw is set. He is, in this moment, doing 2 things at once, trying to find the exit from this argument and starting to understand there may not be one. Vasquez v. EPA, he says carefully, is a Ninth Circuit decision. It has no binding authority in the First Circuit. That's correct, Naomi says. But it has persuasive authority, and more importantly, it was cited in Caldwell v. Department of Interior, 2002, First Circuit. That one does bind. She looks at him steadily. That's on page 12 of the Caldwell opinion. I can give you the citation if you need it. Jordan Park in the front row has found Caldwell. He reads. His face goes white. He slowly closes the laptop. He puts both hands flat on the table in front of him. He stares at nothing. Claire Mendez in row 3 has been writing steadily for 2 minutes. She stops. She underlines something. She takes a photograph of her own notes with her phone. Judge Park speaks for the first time. His voice is quiet. Dr. Webb, I'd like you to take a moment and verify whether Caldwell was cited in your brief. Webb's jaw moves. I'll need a moment to review. Of course. Judge Park looks at Naomi. Ms. Osei, you are not a member of the bar. You are not a party to any case before this panel. What is your interest in this argument? Naomi reaches into her other pocket. She takes out an envelope, folded in thirds, worn at the crease. She unfolds it and places it on the podium next to the Federal Register photocopy. My interest, she says, is that the person most directly affected by this gap has been trying to get someone to look at it for 6 years. Her name is Dolores Whitfield. She's 71. She lives in Roxbury. Her grandfather bought that land in 1946 with money he saved during 22 years of working in the Postal Service. She has no lawyer. She's on a fixed income. She filed pro se 3 times. She was dismissed each time because of the authority Dr. Webb just cited. She pauses. I've been drafting her brief for 4 years. I didn't know how to get it in front of anyone. She looks at the 3 judges. She looks at Webb. She looks at the room. I guess now I do. 1345. What happened next is part of what makes this story hard to believe even when you watch it. Judge Correa asked for a recess. 20 minutes. During those 20 minutes, 2 things happened simultaneously. Marcus Webb's co-counsel, on a phone call in the hallway, confirmed that Caldwell had not been cited in the brief. And Judge Ostroff, at the panel table, asked to see Naomi's 4-year draft. Not as evidence. Not formally. She just asked to see it. Naomi handed it over. It was 61 pages, handwritten and typed, printed on the back of old colloquium programs because printer paper was expensive. It was tabbed and indexed with sticky notes in 4 colors. Judge Ostroff read the first 8 pages during the recess and did not look up once. When the colloquium reconvened, Webb stood at the podium for 90 seconds. He was precise and controlled, because he is always precise and controlled. He acknowledged that the Vasquez-Caldwell lineage raised questions about the procedural foundation of the 1973 reclassification that warranted further examination. He said he would be reviewing his brief. He said he could not, in good conscience, affirm the chain of authority as previously stated until that review was complete. In legal terms, this was a withdrawal. Not formal, not final, but a withdrawal. The room understood it as such. Claire Mendez was already on the phone before he finished speaking. 15:30. Let's talk about what Naomi Osei actually did in that room. She didn't get lucky. She didn't stumble onto a technicality. She found a gap in a widely cited, professionally authored, court-tested legal argument that had been standing for over 30 years. A gap that 3 circuit courts, multiple law firms, and dozens of practicing attorneys had either missed or decided not to look at. She found it not because she had access to better resources than Webb did. She found it because she had access to the same resources, and she actually needed to find the truth. That's not the same thing as being smart. Naomi is smart. We'll get to that. But what she demonstrated in that room was something different. It was the difference between arguing for a position and looking for the answer. Webb had a conclusion and built toward it. Naomi had a problem, a 71-year-old woman losing her family's land, and worked backward until she found why. She also had something Webb didn't. She had 8 years of 4 a.m. hours in an empty building with nothing to do but read. Naomi grew up in Silver Spring, Maryland. Her father was a civil engineer. Her mother was a high school history teacher. She was, by all accounts of people who knew her growing up, one of those students that teachers remember, the kind that makes a teacher feel, for a moment, like what they're doing actually matters. She finished high school with a full scholarship to Georgetown. She started law school at 22 with the kind of focus that comes from knowing exactly what you want and exactly how you got there. And then, in her second year, her mother was diagnosed. And the money that should have lasted through her degree became the money that paid for the things insurance wouldn't cover. And Naomi made a decision, a clean, clear decision, the way she would later make legal arguments, that her mother was more important than her degree. She left. She came back to Washington. She was there for 2 years, until the end. Then she came north, took the custodial job because it paid more than retail, and has been at Whitmore ever since. She did not stop reading. She did not stop writing. She tells it plainly. I was always going to finish the brief. I didn't know who I was going to give it to. I just knew if I stopped working on it, I'd stop believing it was possible. And if I stopped believing it was possible, I didn't know who I'd become. 1830. After the recess, after the withdrawal, after Claire Mendez filed a 400-word breaking item that went regional within the hour, after all of that, the room emptied slowly, the way rooms empty after something real has happened. Marcus Webb did not speak to Naomi. He left with his co-counsel, phone already to his ear. Judge Ostroff did not leave. She stood at the panel table until most of the room had cleared. Then she walked to where Naomi was standing, collecting the last of her papers. putting the manila envelope back in her pocket. "Where did you go to school?" Judge Ostroff asked. "Georgetown," Naomi said. 2 years. "Did you finish?" "No." A pause. "You know," Judge Ostroff said, "the bar exam doesn't require a JD. Not in Massachusetts." Naomi looked at her. "I'm not saying it's easy. I'm saying it's available." Judge Ostroff picked up her things. "You argued better than 3 of the last 4 lawyers I've seen at circuit. The 4th was very good." She paused at the door. "I'd like to read the rest of your brief." She left. Naomi stood alone at the front of a room she had been cleaning for 8 years. In her pocket, the brief she had been writing for 4 years. Outside, Claire Mendez was on a call with her editor. On a couch in a Silver Spring apartment, Naomi's cousin, who had been watching the stream on his phone during his lunch break, was trying to call her and not getting through. Dolores Whitfield's phone, in Roxbury, had not yet rung. It would. 2 hours later. Naomi called it herself. 2040. What happened after is a longer story, still in progress. Naomi passed the Massachusetts bar exam on her first attempt, 14 months later. Dolores Whitfield's case was refiled with new procedural standing. It is currently before the First Circuit. Marcus Webb's brief was formally revised. The revision acknowledged the Vasquez-Caldwell precedent chain. It did not acknowledge Naomi Osei. Claire Mendez's piece ran in the Sunday print edition under the headline, "She cleaned the room, then she changed it." It was shared 47,000 times in its first week. Jordan Park, the law student in the front row who found Caldwell on Westlaw, graduated the following May. His commencement speech contained one story. It was about the morning he saw someone walk to a podium and make every person in the room reconsider what they thought they knew about who belongs where. "I've thought about it almost every day since," he said. Not because it was dramatic, because it was so obviously right. She was right. She had been right for 4 years. And no one had looked. He paused. "I want to be someone who looks." 2210, close. The moot courtroom at Whitmore has a small bronze plaque near the main entrance. It lists the names of notable speakers and participants going back to 1961. It was last updated 7 years ago. Naomi Osei's name is not on it. The trash can she emptied that morning is still by the back door. Same position. Same model. Someone still empties it every week. But the argument she made, the gap she found, is now cited in 3 published law review articles. It is taught, briefly, in the Administrative Law Survey course at Whitmore itself. The professor who teaches it does not know who found it. She attributes it to the Caldwell lineage. Naomi knows. Dolores Whitfield knows. Judge Ostroff knows. And somewhere in Roxbury, in a walk-up apartment, a 73-year-old woman has a folder on her kitchen table labeled, in careful handwriting, "Grandfather's Land, active." It is still active. The story is not finished. But on a Friday morning in a borrowed auditorium, a woman in a cleaning uniform walked to a podium she was never invited to, opened a brief she was never paid to write, and quietly, thoroughly, took apart an argument the room had decided was invincible. She didn't raise her voice. She didn't need to. She had done her reading.